Got a question on TikTok about how a landlord can breach a lease or break a lease without notice. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I'm assuming this landlord's in California because I'm going to be talking about California Civil Code, okay? And there are very few places actually in the Civil Code that like a landlord could break a lease in the term of, like in the idea of like, hey, landlord can just like terminate a lease without notice. Okay, the most common one is you have a fixed lease term, like for like a year, right? Okay, and assuming your Tenant Protection Act exempt under state law and you're not subject to localized just cause or eviction protections at the city or county level, you could end the lease at the end of its term. So like, let's say you have a lease from January 1 to December 31st this year. Well, under normal circumstances, a landlord can insist upon a tenant vacating at the end of the term. You don't have to give a legal notice regarding that. Obviously, you're going to have to check your lease because some leases have automatic renewal provisions in them, or you may be subject to just cause. That's one way you don't have to give notice. A second, but rarer occasion where a lease may terminate, for example, would be the destruction of the actual home or being rented, for example. Okay, we had some wildfires in Southern California, okay, per Civil Code 1933. If the item or the property is destroyed, let's say by a fire, that in and of itself would probably terminate a lease, okay? And some leases require either the landlord or tenant to give notice of their their intent of like continuing on with the lease. Some leases provide provisions, but under the law, basically, if the lease is silent, if the property is absolutely destroyed, you can count that as a lease is terminated. The item has been destroyed. Another situation where it might happen, less rare than probably destruction of the property, is, let's say, tenant buys the property from the landlord. Okay, in that case, your fixed lease. Now I've acquired ownership of the property outright. That's going to terminate a lease. Or in the rare case, and this is really for like a month-to-month agreement, if either landlord or tenant passed away under Civil Code 1934, that month-to-month tenancy or periodic tenancy would terminate on notice of the death or incapacity to contract per Civil Code 1934. So those are a few ways, you can get around, not giving a formal legal notice or not having just cause per se, other than, if you're expired lease term. A lot of places you're going to have cause. So your mileage is going to vary. Obviously, check with local counsel in the area you're in if you're contemplating terminating a lease or ending it, okay? If you're in the Northern California area and you're a landlord or property manager and you need help with something like this, feel free to reach out. I might be able to help out, okay? Until next time, folks, talk to you then. Put your comments, questions down below. I'll try to answer them to the best of my ability. Thanks.